by Rajeev Gowda.
Sir, I dedicate this speech to the memory of Nirbhaya, and my heart, like the rest of the nation's, goes out to her family. After that horrific tragedy, the UPA government established the Justice Verma Committee and brought in the Criminal Law Ordinance, and this bill aims to take these efforts forward. So it's very important that juvenile perpetrators of heinous crimes are suitably punished. But let us remember that the law that we make today will not apply to the perpetrator of the tragedy that is foremost on our minds. Instead, they will apply to every child who is charged in the future. Therefore, the main issue we must consider is whether or not the proposed changes will reduce crimes committed by juveniles and whether this bill will result in an improvement in reformation of juveniles who are found guilty. Therefore, the questions before us, sir: what is the best way to achieve these goals? What is the impact of the process and punishment methods that we have chosen? Do we have the capacity, institutional and scientific, to follow through? Will our choices meet the requirements of our Constitution, our international conventions, and principles of natural justice? So the key issue that is agitating the nation right now is the issue of transfer. For example, Clause 15.1 of this bill says that when a child above 16 years of age is alleged to have committed a heinous crime, the Juvenile Justice Board will conduct a preliminary assessment of his mental and physical capacity to commit the crime, the ability to understand the consequences, the circumstances, etc. Then, if the board decides, the 16-year-old's case can be transferred to the adult justice system. What effect will this have? Will it achieve our goal? Will it implement it fairly? Will it cause more harm than good? Can it survive constitutional scrutiny? So first, studies from the US where they send children to the adult justice system have shown that sending juveniles to adult prisons is like sending them to schools of crime. When we house at-risk youth with adult convicts, we create hardened criminals who emerge as bigger threats than before. So, second issue, the JJ board is supposed to determine whether a 16-year-old should be tried as an adult. Unfortunately, neither medical science nor psychology is currently capable of providing an accurate assessment of the factors involved. So in India, we have special laws for children because there is a need for it. And all individuals below the age of 18 are children. While the cognitive levels of a particular 16-year-old may match that of an adult, findings show that they lack in psychosocial maturity levels when compared to adults. Adolescents are more prone to peer influence, they're less likely to focus on future outcomes, they're less risk-averse than adults, and evaluate risks and benefits differently. Further, their ability to understand legal processes and make decisions related to these cases is not the same as adults. So turning to institutional capacity, already my colleague Vandana Chauhan has already spoken about the lack of institutional capacity, and that is a matter of grave concern. If our JJ boards do not have the trained manpower to do a reasonable job of preliminary assessment, if such qualified JJ boards are not available in every district, then are we not setting up a system that will fail in achieving our goals? So let me turn to the constitutionality of this law. So under Article 15.3 of the Constitution, we are allowed to make laws that protect our children, but not one that is against our children, as this law attempts to do. No preliminary assessment can be the basis for depriving a person of his or her rights under the juvenile justice system. So further, treating juveniles aged 16 to 18 differently based on a criterion which is as undeterminable as mental capacity, we are inviting courts to strike down this law as arbitrary. We must take these points into consideration, otherwise all this hard work will go to naught and the law will be struck down. Similarly, sir, when we consider whether a person has undergone reformative changes or can be a contributing member to society, such assessments are fundamentally subjective, they are prone to arbitrariness, and will be inequitable. Talking of inequitable outcomes, again, multiple colleagues of ours have talked about who will be the most affected by these kinds of laws. It will be the poor, it will be the dispossessed, it will be the marginalized and the disadvantaged. Those who are wealthy will be able to argue before the JJ board and get away with just a scolding. So another side effect of this law occurs when youngsters below 18 indulge in consensual sex and get caught. In India, there are numerous instances where parents will treat this as an issue of honor and charge one of the persons involved with rape. Then the accused youngster can be thrown into the adult system, brutalized, and as the disqualification discussion went on, it could be barred from all kinds of employment in the future. So any legal system must be one where not even one innocent person is penalized. Here, there is a chance of the opposite occurring, and the bill will do more harm than good. So the task before the nation is to create a system which focuses on reformation. And if you look at the data that has been offered today, whether by the minister or Rajeev Chandrasekhar just now, they talk in percentages, they talk in anecdotes. When at the standing committee on HRD, of which I was a member, looked at the data from the criminal records, etc., we found that they were not accurate, they were based on FIRs and not actual convictions, and therefore in the absence of absolute data, and when we see that the actual percentage of crimes committed by juveniles is about 1%, not these huge percentages that are being bandied about of our total crimes, we have to be much more circumspect in the way we go forward. Okay. So, Rita Brata has also spoken about the UN conventions and how this law does not match what we have committed to internationally. Anyway, sir, let us focus on strengthening our system. Let us focus on changing the maximum penalty, changing the amount of time that a juvenile can be kept within the process so that the reformation process actually occurs. And let us remember that hard cases make bad laws. Let us do the right thing for our children rather than take the easy way out. And finally, sir, let us remember the words of Nelson Mandela. There can be no keener revelation of a society's soul than the way it treats its children. This bill is a reflection on that. Thank you, sir.
Okay, so